Thank you so much, Eric, for your kind introduction. And it is my absolute pleasure to be part of this summer school. And I wish to thank Anna and Eric for your kind invite. So, as Eric said, the theme for today's lecture is arbitration and environmental disputes. And I would like to focus on investment arbitration for today. And this is because the wave of withdrawals from the Energy Charter Treaty Eric just mentioned, has brought renewed attention to the debate surrounding the investment environment conflict. This lecture discusses the key legal and policy challenges at the intersection of investment arbitration and environmental measures of the host state. According to the UNCTAD report, issued 3 years ago, 2022, observed that cases relating to environmental regulations occupy about the 50% of all known investor-state dispute settlement cases based on investment treaties or international investment agreements, IIAs. Also, according to the latest exit case law statistics, cases in the oil, gas, and mining sector occupy 38% of all cases. Given that disputes in this sector directly or indirectly concern climate change and environmental regulations, environmental regulation-related cases occupy a great portion of all investment arbitration cases. This, in turn, has given rise to concerns over the investment environment conflicts. So Mr. David Boyd, the United Nations Special Rapporteur on the issue of human rights obligations relating to the enjoyment of healthy environment, issued a report which is highly critical of investment arbitration or investor-state dispute settlement. The report describes ISDS as a daunting obstacle for states to take climate and environmental action to fulfill their human rights obligations. So the concerns over environment investment conflicts have been raised from many directions. First, it is sometimes claimed that investment arbitration tribunals are focused primarily on investors' rights and give much less attention to host states' rights to regulate. So investment arbitration is biased in favor of investors. However, according to the UNCTAD data, in ISDS cases filed between 1987 and 2023, 38% of all cases were decided in favor of states, and 13% of the cases were discontinued. In 3% of the cases, the host state breach was indeed found, but no damages were awarded. So therefore, generally speaking, and contrary to the claim that ISDS is biased in favor of investors, we can actually witness that the odds have been slightly in favor of state, not investor. That said, if we specifically look at investment arbitration cases concerning fossil fuel, we see a slightly different picture. As this chart shows, in fossil fuel arbitration, the odds seem to be in favor of investor. Indeed, amongst the cases that proceeded to the merits phase, 72% of cases were decided in favor of investor. The second concern over ISDS is that it causes the so-called regulatory chill. Regulatory chill refers to the situation where the host states refrain from introducing new regulations for fear of future investment disputes. The existence or absence of a regulatory chill is a controversial question. The Nobel laureate economist, Professor Joseph Stiglitz, who is a strong opponent against ISDS, supports the existence of phenomenon. He claims that ISDS cases having a chilling effect on implementing the stringent climate regulations required to fulfill a pact to curb global warming. By contrast, many scholars argue that there is no evidence which would support the claim of a regulatory chill. It is even argued that the regulatory chill-related arguments have been exaggerated in the context of backlash against ISDS beyond reality. So in this regard, the case of Estelle versus Canada has been often cited as a proof of the existence of regulatory chill. This case involved the MMT Act that prohibited the commercial importation and interprovincial trade of MMP, which is a fuel additive for certain environmental concerns. Estelle commenced NAFTA arbitration proceedings, arguing that the measure, the ban of MMP, was illegitimate and discriminatory. After the tribunal confirmed its jurisdiction to hear the claim, Canada settled the case with Estelle Corporation for $13 million. The settlement was criticized that ISDS threat made Canada pay compensation for its legitimate environmental measures. However, there is another story to this settlement, according to the opponent to the existence of a regulatory chill scholars. There is another story to this settlement. Outside the ISDS proceedings, several provinces that were affected by the MMT Act had challenged the act as inconsistent with Canada's agreement on internal trade, AIT. A domestic Canadian panel convened under this agreement concluded that the MMT Act failed to comply with Canada's obligations under the AIT. That is, Canada's own tribunal had concluded that the MMT Act was in contradictory with the trade agreement. Therefore, these scholars argue that the AIT panels made the case effectively indefensible for Canada. So therefore, it is incorrect, according to them, it is incorrect to describe the case as an example of a regulatory chill caused by ISDS. So one observation that supports the absence of a regulatory chill is that only 9% of exit cases actually resulted from legislative acts. In other words, the vast majority of ISDS cases are not brought on the basis of legislative acts, but rather due to executive acts. And therefore, the theory that ISDS restricts countries' regulatory power does not have its basis. However, once again, if we look at the regulatory chill arguments in the context of climate change, there is a case which has been oft cited as an example of a regulatory chill, which is called the Euro law case. In July 2017, the then French Minister of Ecological and Solidarity Transition, Mr. Hulot, drafted a law to put an end to fossil fuel extraction on all French territory by 2040. In the following month, the Council of State received several lobby letters on the law. They included a letter from a Canadian oil company called Vermilion, in which the company threatened to sue France under ISDS if it pushed ahead with the Euro law. After the summer, the Euro law returned to discussion. However, this version, the September version, allowed for the renewal of oil exploitation permits until 2040, meaning that all current exploration and exploitation projects would survive. It is unknown, of course, whether or not, or to what extent, the ISDS threat by Vermilion played a role in the water down of this law and its climate ambition. Nevertheless, in this respect, the question remains whether climate change has a unique feature that can actually cause regulatory reluctance on the part of the host state. That is, climate change is a public good, and the impact of climate change is global, and locals are arguably less directly affected by climate change than by, for example, open pit mining projects conducted in their inhabiting areas. This can consequently cause the problem called the so-called free rider problems. That is a government faced with bearing the full financial cost of climate mitigation arising from ISDS may be less inclined to act in a globally efficient or optimal way because they do not capture the full global benefit of the mitigation action. So at any event, the concern that investment treaties may hinder the effective implementation of climate change measures has resulted in the wave of withdrawals from the Energy Charter Treaty. The discussion concerning the modernization of the text of the ECT Energy Charter Treaty started in 2017 and ended in 2022 when the member states reached an agreement in principle. Importantly, the modernized text did mention climate change and clean energy transition goals as one of the central objectives of the Energy Charter Treaty. On the other hand, the modernized text does not exclude fossil fuel investment from the scope of its protection. Instead, it provided a flexibility mechanism that allows contracting parties to list in Annex investments that are not to be treated as a protected investment for the purposes of the treaty. This was considered as a failure to save the climate. NGOs criticized that the reform, the modernization, was a failed chance to use ECT to agree on halting new investment in fossil fuels. And as a result, as you know, all major European countries, EU member states, plus the United Kingdom, like they all already withdrawn or announced the withdrawal from the Energy Charter Treaty. So, I will come back to the issue of climate change and investment arbitration shortly. So the important question is whether or not the investment arbitration tribunals have actually ignored or disregarded the host state's legitimate environmental concerns in their decisions. And in fact, many scholars observe that arbitral tribunals have followed a balanced approach when applying and interpreting protection standards, investment protection standards, weighing investment protection against the inherent right of the sovereign state to regulate. But Judge Brower even argued that no ISDS tribunal has ever found that a legitimate environmental or health law or regulation of a state breached an investment treaty. Identified here are some of the most recent awards that discuss the defendant state's environmental measures. We can observe that many cases actually dismissed the investor's claims on the merits. In Discovery Global versus Slovakia, Slovakia amended its Environmental Impact Assessment Act to apply the requirement for an EIA, Environmental Impact Assessment, to exploration drills after it granted exploration licenses for the claimant's investment drillings. The amendment was done with a view to meeting the EU law requirements. The claimant argued that these requirements destroyed the stability of the investment framework, their investment framework. However, the tribunal rejected this argument. It said that there is a large consensus in investment arbitration that, absent a stabilization clause or a specific commitment of regulatory stability, an investor cannot legitimately expect that the state will not change its legislative and regulatory framework over time, provided the changes are reasonable, proportionate, non-discriminatory, and conform with due process. Then it concluded that the claimant in this case cannot reasonably assert that it had a legitimate expectation not to be subjected to an EIA requirement, or to be entitled to a regime of regulatory stability based on the licenses, the BIT, bilateral investment treaty, the EU law framework, etc. Next case, Gabriel Resources versus Romania, a mining company filed for arbitration after large-scale gold and silver mining project is stalled due to the refusal of required environmental permits. In this case also, the majority of the tribunal found no breach of investment protection provisions in the state's conduct, including the state registering the mining site as a UNESCO World Heritage Site. The next two cases, Montauk Metais versus Colombia and Red Eagle Exploration versus Colombia. These two cases are brought by foreign mining companies against Colombia following the state's decision to prohibit mining activities in a region called Paramos, which includes a range of high-altitude wetland ecosystems that are crucial for the country's water supply. Both tribunals found that the case did not fall in rare circumstances to find indirect expropriation and dismissed the claims. By contrast, the majority of the tribunal in a case called Odyssey Marine Exploration versus Mexico found a breach of the fair and equitable treatment standards arising from a refusal of an environmental permit for seabed mining, on the grounds that the refusal resulted from political reasons rather than from legitimate environmental concerns and lacked due process. Arbitrator Philip Sands dissented, arguing that the assessment of the alleged breach of the fair and equitable treatment standard should have accounted for the respondent's international legal obligation to protect the environment and adhere to the precautionary principle. So this is obviously not a place to revisit the findings of the majority of these cases, but critics say that the mining project caused serious concern over a risk of adverse environmental impact on ecosystem and endangered species. In particular, for Odyssey Marine Exploration versus Mexico, this case was funded, the claimant in this case was funded by a third-party funder to finance the arbitration. And therefore, environmental NGOs criticized the majority's decision that it only enriched the third-party funder. So how about then the cases concerning climate change? Although still limited in number, there are investment arbitration cases related to phasing out of fossil fuels. Uniper and RWE were raised against the Dutch legislation that seeks to phase out of coal-produced energy by 2030. So these two German investors challenged the Dutch legislation to end coal-powered energy by 2030. And both cases were either withdrawn or discontinued. But in 2022, not investment arbitration, but the higher regional court of the home state of the investor, the higher regional court of Cologne, declared that they were inadmissible due to the intra-EU nature of the underlying disputes. The German court also assessed the impact of the Netherlands coal phase-out legislation under the framework of provisions contained in European human rights instruments that protect the right to property, in particular Article 1 of the first protocol to the European Convention on Human Rights. Applying the fair balance test that has been set out by the European Court of Human Rights, the German court notably found that although the coal phase-out legislation did interfere with the German investors' property rights, the coal phase-out legislation should be qualified as a case of property regulation rather than a de facto expropriation. In light of pre-existing developments in international climate policy, both RWE and Uniper could have reasonably foreseen at the times when they made their investments that the Netherlands would adopt additional measures aimed at reducing greenhouse gas emissions. In light of these findings, the German court concluded that the coal phase-out legislation had struck a fair balance between investment protection and the need to protect public interests, meaning the climate change protection. Taking climate change action. Consequently, the compensation claims raised by these German investors were dismissed at a local court in Germany. The second case, the TC Energy Corporation and Alberta Petroleum marketing cases, concern the Biden administration's decision to cancel the Keystone XL pipeline project. Keystone XL pipeline project aimed at transporting crude oil, sand oil from Alberta, Canada, to refineries in the United States. This was the second case brought by TC Energy against the United States on the Keystone X pipeline project. The first case was actually discontinued in 2017 following the issuance of a required presidential permit by the then newly elected Trump administration. The Biden administration's revocation of the pipeline's permit once again in January 2021 gave rise to the second case. And now it is reported that President Trump started discussing the resurrection of the Keystone XL pipeline project, which may lead to further development of these cases. More recent case, ZEP Investment versus Australia, was filed by a Singaporean investor against Australia, challenging a refusal of the environmental permit of a coal mine proposed by its subsidiary in Australia. The Queensland government follows the recommendation by the Queensland Land Court that the Queensland authorities should refuse to grant a mining lease and the environmental authority for the coal mine in Queensland. Amongst other things, the court based its recommendation on evidence of climate change and human rights impacts deriving from the project, taking account of the Scope 3 emissions associated with the burning of the coal produced by the mine. Ruby River Capital versus Canada arose from the rejection of the proposed LNG facility proposed in Quebec. The government justified their decisions based on a variety of factors, including anticipated negative net contributions to global greenhouse gas emissions, deceleration of energy transition through foreign energy imports, etc. Westmoreland Coal Company versus Canada, these cases arise out of a policy by the Alberta government to pursue the phase out of coal-generated electricity. And these two cases were dismissed on its jurisdictional phase. Asienta Electrica versus Germany, which is probably the latest coal phase out related investment arbitration case, was filed by a Swiss investor against Germany, challenging German's Coal Ban Act, German 2020 coal ban law that required shutdown of coal plants constructed in early 2000s and provides differential treatment between coal-fired plants and lignite-fired plants. And this is still ongoing, but the German government frames the case as a request that the tribunal will be the first investment treaty tribunal ever to order a state to pay damages for a legislative measure dedicated to climate action. So far, all these cases are either withdrawn, discontinued, or still in progress and pending. There are two cases that are sometimes classified as climate change related investment arbitration cases and which have resulted in awards. One is Rockhopper versus Italy, and the other is Lone Pine versus Canada. Lone Pine Resources by Canada, the claims were dismissed on their merit. But in Rockhopper versus Italy, this case actually resulted in compensation. This case arose out of Italy's law introduced in 2016 that barred oil and gas exploration and production activity using fracking within 12 nautical miles of the coastline. Rockhopper, a British company, had been engaged in exploration activity in 6 miles of eastern coast of Italy, and therefore it became unlikely that the production concession for Rockhopper's project would be issued. This case was based on the energy charter treaty. The tribunal concluded that the claimant had, in August 2015, the claimant had a full right to a concession. And into the following year, the concession was taken away. So, and the tribunal basically opines that the claimant went in one fell swoop from a position where they had right to a valuable production concession to essentially nothing at all. The tribunal added that this amounted to an immediate and complete deprivation of the claimant's investment, qualifying as a direct expropriation under the Energy Charter Treaty. The tribunal also, at the quantum phase, calculated the amount of compensation based on the discounted cash flow method, based on the finding that the Rockhopper project was a going concern. So this case has been criticized, heavily criticized by environmental NGOs as serving no climate justice. However, an important caveat should be made here. The regulatory measures challenged in Rockhopper and Lone Pine, like these cases, were not designed primarily to decarbonize the economy. But these measures were based on the concerns regarding fracking, the technology called fracking, and its impacts of water contamination, its damage on ecosystems, etc. So many scholars and many practitioners actually argue that categorizing these two cases as climate change investment arbitration would be simply misplaced. But this is controversial, but anyways, the Rockhopper versus Italy has been cited as no climate justice investment arbitration case. And therefore, anyways, climate change investment law conflicts has become a big issue. In reaction, the most recent investment treaties started to make references to climate change. So for the purposes of this lecture, I conducted a small survey of 137 investment treaties signed after 2020 in the last 5 years. The results shows that about 16% of investment treaties do include reference to climate change. That said, most of these 20 IIAs that provide climate change references do not provide investment arbitration or ISDS, investment code or whatever. So the implications of these provisions for arbitration is probably limited. So these clauses, these provisions are included in, for example, the United Kingdom, New Zealand FTA investment chapter, United Kingdom, Iceland, Liechtenstein, and Norway Free Trade Agreement investment chapter. But exceptions do exist, and they include the Hungary, Georgia, BIT, the Canada, Ukraine modernized FTA, and the recently adopted African continent free trade area investment protocol do make references to climate change. And they are still discussing whether or not to include ISDS. It remains unclear if they introduce investment arbitration in the end into the framework of the AFC FTA framework. So, lastly, I would like to briefly discuss corporate environmental responsibility in investment arbitration. So, environmental protection is a sine qua non for numerous human rights, as Judge Weir-Mantry stated in his separate opinion in the Capticover project case. Growing concerns over environment investment conflict and the recognition of corporate environmental and human rights responsibility in society have produced criticisms against the one-sidedness of the investment treaty-based dispute settlement mechanism, where the host states are kept as perpetual defendants. It is only the investor who can file claims like before investment arbitration. And in addition, states and scholars increasingly see the protection and promotion of foreign investment not as the end itself, but as a means to achieve sustainable development objectives, for which responsible investment is a necessary element. With this background, there is a greater recognition of the need to reflect corporate environmental responsibility in investment arbitration. And also, according to my survey, this recognition started to be reflected in the development of most recent investment treaty making. So according to this data, nearly half of the most recent investment treaties signed after 2020 include references to corporate social responsibility and business responsibilities. Content-wise, however, these CSR provisions are typically addressed to contracting states, not investors. That is, they provide that the contracting parties should encourage, or the contracting parties reaffirm the importance of encouraging enterprises to voluntarily incorporate international CSR standards. So as the second chart shows, CSR and other provisions concerning business responsibility addressed to investors are more limited in number. And they are non-binding, typically non-binding. Investors or corporations should endeavor to incorporate international standards on CSR, etc. So it is very rare that investment treaties provide investors binding obligations. This actually remains the same for most recent, the last 5 years, investment treaties. Only 2 out of 137 investment treaties I looked at provided such obligations, binding obligations of investors. Let's look at these rare provisions on investors' binding obligations. They do differ between investment treaties. Starting from the bottom, Article 9, the classic example of investors' binding obligations in an investment treaty, is found in the 1981 Organization of the Islamic Conference Investment Agreement. Article 9 of this agreement provides the obligation to abide by the host state's laws and regulations and to refrain from acts that may disturb public order or morals, or that may be prejudicial to the public interest. Then Article 19 of the 2016 Morocco-Nigeria BIT is more progressive than the OIC investment agreement in the sense that it requires that adoption of internationally accepted standards in corporate governance and establishment and maintenance of local community liaison processes. A more recent AFC-FTA protocol on investment also incorporate internationally recognized standards. And it also should be noted that as an intra-African BIT, the Morocco-Nigeria BIT will be terminated within 5 years after the entry into force of the African Continent Free Trade Area Investment Protocol. To sum up, although still limited in number, there is an observable trend towards the inclusion of investor obligations in the most recent investment treaties. These investment treaties incorporate international standards concerning business conduct and CSR standards, either as a mandatory requirement, which is still very rare, or as an endeavor obligation. So I would like to conclude my lecture by briefly discussing counterclaims as a way to incorporate investors' environmental and human rights responsibility in investment arbitration. The defendant states have actually raised counterclaims in many cases based on like environmental and human rights damage allegedly caused by the investor. Counterclaims do have certain benefits in investment arbitration. Discussing and deciding multiple issues in a single proceeding would serve to holistic solution of a dispute. Counterclaims also may allow arbitration tribunals to incorporate external norms to the investment treaties, the relevant investment treaties, such as environmental and human rights obligations, into the resolution of the dispute. Counterclaims, that said, face various jurisdictional hurdles, and many counterclaims have been dismissed at the jurisdictional stage. However, although limited in number, there are cases in which jurisdiction and admissibility of counterclaims were established. However, amongst these, only in 2 cases, that is Burlington versus Ecuador and Ferenco versus Ecuador, the host state's counterclaims succeeded on the merits. So these 2 cases arose out of the same set of facts, the same oil mining concession consortium, and challenging the windfall tax imposed by Ecuador. In this case, Ecuador filed counterclaims on the grounds that the claimant's breach of environmental laws caused environmental damages in certain oil blocks. The tribunal did order the investors to pay compensation to the state in both cases. However, I say many howevers, these 2 cases were exceptional because the tribunals found the jurisdiction of the counterclaims on the explicit or tacit consent by the claimant investor. In the remaining cases, counterclaims have always been dismissed at the merits phase. So the first case, Al-Warak versus Indonesia, this is not a case about environmental protection, but this is the first case where a counterclaim based on a provision on the investor's obligation in Article 9 of the OIC investment agreement was held admissible. In this case, the claimant investor was the owner of an Indonesian bank called Bank Century, and the dispute arose out of criminal proceedings concerning the bailout of the bank. The Indonesian Central Bank alleged, amongst others, that bailout funds had been used to fund the 2019 presidential election campaign. The claimant was convicted of corruption and money laundering and theft. And Mr. Al-Warak's assets in Indonesia were confiscated, and he filed claims to investment arbitration based on the OIC investment agreement. Then Indonesia filed a counterclaim based on the allegation that the claimant investor unjustly enriched himself by banking fraud, which resulted in the loss of Bank Century, etc. So the tribunal confirmed the admissibility of the counterclaim on the following grounds: lack of a definition, like a broad definition of disputes in the relevant investment agreement, the OIC agreement, and that Article 9 of the agreement, which prescribes a variety of investor obligations, would support for the broad interpretation of jurisdiction over counterclaims. The tribunal then, however, dismissed the counterclaim on its merits on the grounds that the counterclaim did not distinguish the actions of the claimant, Mr. Al-Warak, from the actions of various other entities. Like, in short, Indonesia failed to define Mr. Al-Warak's personal liability separate from all relevant individuals and entities not party to arbitration. So, but the counterclaim in this case was based on Article 9, one of the rare provisions that prescribed investors' binding obligations in the relevant investment treaty. So what if the relevant applicable investment treaty does not include any binding obligations of investors? Counterclaims are still possible. A case called University versus Argentina introduced a new potential in counterclaims by admitting the possibility of invoking the investor's international obligations in counterclaims, even though the relevant investment treaty did not contain such investors' obligations. This case concerns a concession for water services to be provided in Buenos Aires, granted to a company in which the claimant had shares. The claimant alleged that Argentina's measures, including the emergency measures taken after the economic crisis, rendered it difficult to operate the concession, which was eventually terminated. In response, Argentina raised counterclaims on the grounds that by failing to make the investments under the water service concession, the claimants violated the principle of good faith and pacta sunt servanda that are recognized both by Argentina law and by international law. It further argued that such a failure affected human rights as well as the health and the environment of thousands of persons, most of which lived in extreme poverty. The tribunal first confirmed the host state's right to bring counterclaims under the Argentina-Spain BIT on the grounds the broad definition of disputes in the dispute settlement clause. Then the tribunal proceeded to state that in light of the recognition of corporate social responsibility in the international law sphere, it can no longer be admitted that companies operating internationally are immune from becoming subjects of international law. Referring to the 1948 Universal Declaration on Human Rights and the 1966 International Covenant on Economic, Social, and Cultural Rights, the tribunal stated that the investment, the Spain, United States BIT, has to be construed in harmony with other rules of international law of which it forms part, including those relating to human rights. Significantly, the tribunal acknowledged that an obligation to abstain, like a prohibition to commit acts violating human rights, can be of immediate application to private parties. Also demonstrating this potential is the case of Aben versus Costa Rica, which arose from the claimant's investment in a tourism project. Neighbors to the claimant's project site raised concerns and complaints about the negative environmental impacts on wetland and forest ground, and Costa Rican authorities undertook inspection, which resulted in the reassurance of a judicial injunction against the continuance of works and other measures. Criminal proceedings against individuals, including the claimant, Mr. Aben, were raised on the ground of a violation of local environmental laws. Mr. Aben and other claimants went to investment arbitration, arguing that Costa Rica's measures preventing the project amounted to a breach of the fair and equitable treatment standard and expropriation obligations under Chapter ER. In turn, Costa Rica raised counterclaims asserting that unlawful work carried out on the part of the investor caused environmental damage to a wetland and thereby violated domestic provisions, as well as the customary international law to respect the environment. In this case, the tribunal agreed with the Universal Tribunal's affirmation that investors operating internationally, the multinational corporations, cannot be immune from becoming subjects of international law. On this basis, the tribunal found its prima facie jurisdiction over the counterclaim. The approach adopted by the Universal and Aben tribunals clearly suggests that where there is international law, either customary or treaty-based, that provides binding obligations applicable to the investor, private entities, rules drawn from it can be relied on as primary rules by the host state in pursuing a counterclaim. Nevertheless, counterclaims were dismissed in both of these cases. These cases point out counterclaims based on external international law would face the same obstacle, that is the seeming lack of secondary rules. Even though counterclaims can be based on like primary international customary law or treaty law on environmental protection that binds private entities, there is a seeming lack of secondary rules, which I defined as the rules that determine the consequences of failure to fulfill obligations established by the primary rules. That is, there are no international instruments that provide the consequences of a breach of international environmental or human rights obligations by private corporations, nor is there customary international law in this regard. So this underscores the importance of introducing some reforms to the existing investment treaty regime. The first reform option would be to provide investor obligations in investment treaties. Practical implications of this reform option will vary depending on the content and scope of the obligations. The baseline requirement would be the obligation, like Article 9 OIC agreement, to comply with the host state's laws and regulations. By contrast, the most extensive obligations would be the hard obligations to apply international environmental management standards, corporate governance standards, or environmentally sound technologies, even if they are more stringent in their demands than the domestic standards of the soft state. Some scholars also propose incorporating the principles on business responsibility under the United Nations guiding principles on business and human rights, thereby hardening these soft laws in investment treaties. So such provisions should also be accompanied by secondary rules in the investment treaties. This would provide a clear ground of remedy for investors' international wrongs. So at any event, the fundamental value of the reform towards the recognition of investor responsibility is that it sends a clear message to the participants and audiences of the investment treaty regime, including states, investors, tribunals, and citizens, that the system does recognize the reciprocity of obligations. This will confirm the direction the IIA investment treaty regime should take in the future, that is towards a greater recognition of the concept of responsible investments. So that's all. Thank you very much.